Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. The public was recently privy to the state of Idaho's sealed motion in limine regarding the 911 call. Judge Stephen Hippler had originally sealed this document upon its filing on the 24th of February 2025. The court later released this document for the public's view, and you can read it for yourself regarding the now redacted state's motion in limine regarding 911 call. It is available on the Idaho Cases of Judicial Interest website at this link. It appears that upon a review of this document, the defense may experience some difficulties in opposing what the state is asking for here. Number one, because there's been some rulings that we are finding out for the first time that Judge John Judge, who was the prior jurist overseeing this case before it was transferred to Ada County, had made some rulings favorable to the state and consistent with what the state is asking for here. What is the state asking for here? In a nutshell, the state wants the 911 call introduced into evidence at the forthcoming trial that is scheduled as of now to begin in the summer of 2025, so that the jury will be able to hear this information, hear the 5 people that were involved in this call, including the 911 dispatcher, and address any objections that might be made at trial by the defense that this information is not admissible because it is hearsay, by filing this motion in limine, seeking a pre-trial order from Judge Hippler that it will be admissible into evidence as an exception to the hearsay rule. Let's take a look at what's going on here. If you look at page 1 of this in limine motion, you will see here that the state of Idaho, by and through the Latah County prosecuting attorney, respectfully moves the court for an order in limine allowing the state to admit the recording and transcript of the 911 call to Whitcomb on November 13th, 2022. The 911 recording was discovered as AV, and it gives the number, and the transcript was discovered as Bates and gives the number. When you say discovered here, this term means it was previously provided to the defense in discovery with these numbers attached to it. A point that I'd like to bring up here is that the state is seeking an order in limine. That is what a motion is. A motion, whether it's a motion in limine, a motion to compel discovery, or any other type of motion, is an application for a court order. Secondly, because this is a motion in limine, the court previously provided a schedule of when the defense's response, if there's any response in opposition, which we anticipate, give our opinion that we believe there will be, that is due March 17th, and then any replies from the state of Idaho to the response that the defense may make due March 25th, and then finally the hearings per this order previously rendered by Judge Stephen J. Hippler on March on January 31st, 2025, will occur on the 9th of April, and if necessary, also on the 10th of April. That's the schedule for the briefings, and then for oral argument, and then ultimately Judge Hippler will render a ruling whether to grant or to deny this motion. Let's take a look at what's contained here. And if you go to page 2, facts section, these are the facts according to the state. The facts pertinent to the issue raised by this motion can be found in the attached excerpts from the grand jury transcripts. Now, some of these things are under seal from the public, so you're not going to see all of these exhibits attached to this motion, unfortunately. If you go into the argument section, the state asserts the statements on the 911 call are hearsay, but fall within firmly rooted hearsay exceptions and should be allowed. What does this mean? Well, the state is saying here, yes, we recognize that this is hearsay. What's hearsay? Hearsay is an out-of-court statement that is rendered for the truth of the matter asserted. The state is saying, yes, we recognize this is hearsay. We're not going to argue that it's not, Judge, but there are exceptions that are firmly rooted in the law that allow something like this 911 call that was made out of court to be entered based on two exceptions they raise here. Present sense exception, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. That would be the person speaking it, the declarant. 2, excited utterance, a statement relating to a startling event or condition made while the declarant was under stress of excitement that it caused. And sometimes when they hear stress of excitement, this doesn't mean a happy thing necessarily. This could be under tremendous stress. It could be pain. It could be bewilderment, can't believe what they're seeing or hearing. The state goes into, for the next couple of pages, case law, both at the federal level and at the state level. For example, this first case cited in support of their position that this information should be admitted as an exception to hearsay, U.S. versus Mitchell. That is a Third Circuit case, Third Circuit Court of Appeal from 1998. That's a federal appellate opinion. Now, if you go to page 4, you will see now that the state is returning to the issue before the court here in the case. When you see this term at the top of page 4, first full paragraph, in the case at bar, that means the case before this court. That means we're going to turn from all of these other cases that stood for the proposition, Judge, that you should grant this motion, and now start talking about the case at bar, which is the state of Idaho versus Brian C. Kohberger. In the case at bar, most of the declarations made were present sense impressions. H.J. located the unresponsive body of Xana Kernodle and informed B.F. and D.M. to call 911. This is new information to the public. After finding the body and informing B.F. and D.M. to call 911, we learn also E.A. was present at the time, new information. All declarants personally perceived the event, i.e. Kernodle unresponsive. The majority of the declarations were describing to dispatcher Carolina Calvin what they were perceiving, i.e. present sense impression. Those statements related to Kernodle being passed out and not waking up. The declarations were made immediately after H.J. discovered Kernodle's body. So there's a lot of information here being released to the public for the first time in this case, where so much has been withheld from the public under seal. So then we go on to the next section, where we see Some declarations made would also be considered excited utterances. This is another exception to the hearsay rule. Those statements include, quote, "Oh, and they saw some man in their house last night. Yeah," end quote. This is a very interesting statement to me, because the position that only one of the roommates, DM, saw the man in black. Going back to the December 29th, 2022 statement under oath, that's called the probable cause affidavit, signed and filed by Detective Brett Payne, who referenced DM seeing this man clad in black. But here it states, "Oh, and they saw some man in their house last night." Yeah. So is this just in the excitement and the pressure of the moment that whoever said, "Oh, and they saw some man in their house last night"? Yeah. Is this actually what was told to this third party, that they, meaning both roommates apparently, saw some man in their house last night? Yeah. It then goes on, as well as the heaving, breathing, and crying that can be heard through the call. So this sounds like quite an emotional call, understandably so, in my opinion. The declarants were responding to a startling occasion, discovering of unresponsive roommate. The statement regarding a person being in the home is in direct response to why Kernodle might be passed out. All statements are made while the declarants are processing what is happening and were made before an opportunity to reflect and fabricate why Kernodle is unconscious. Clearly, the statements of BF, DM, EA, HJ, and the dispatcher Carolina Calvin fall within the hearsay rule exceptions. Now, this is where I believe the defense is going to have a difficult time battling this motion in limine because of what we see here at the bottom of page 4. There was a prior ruling by Judge John Judge, prior jurist in this case, favorable to the state of Idaho. We are learning this now for the first time as the public. It says here, Judge John Judge has already ruled that the 911 call is not hearsay, i.e. not offered for the truth of the matter asserted. End of quote. That is what hearsay is. And even if deemed hearsay, the exceptions for present sense, impression, and excited utterance apply. So both of these things that the state is asking the court, this is now Judge Stephen J. Hippler, to rule in their favor, depends on a ruling that's already been made in their favor, that yes, the exceptions for present sense, impression, and excited utterance apply, as ruled upon by Judge John Judge in this case. They then provide us with further details here. On August 23rd, 2023, defendant moved to dismiss the grand jury indictment. One basis for that motion was that the 911 call was, quote, improperly admitted. So we then look at the rest of page 5, and it says here, sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct, citing to the pages therein filed on December 15th, 2023, because this was all under seal when the defense attempted to challenge the grand jury indictment. The public had no information regarding the same until now, so this is all new information to the public. Regarding the emotion in the caller's voices, Judge Judge further held that the evidence was relevant, quote, as to why law enforcement was sent to 1122 King Road on November 13th, 2022, as opposed to just EMS, when the call was for an unconscious individual, end quote. And then the state continues, this testimony was deemed relevant to the effect that it had on dispatcher Calvin and was not cumulative of Officer Nunez's testimony. Now this is rather interesting because it's stating here Officer Nunez's testimony. This may be providing the public with information not previously known, which was who was the first responding officer. And it says here, Officer Nunez's testimony related to the 911 call. This seems to suggest very strongly that Officer Nunez was the first of what would be many responding officers from Moscow Police Department on November 13th, 2022. Next section. The statements made on the 911 call are admissible regardless of whether or not the witnesses testify. Now, this is a little bit curious. It should not, I believe, be taken that some of these witnesses may not testify, but just giving another argument why this information should be admitted as, although it's hearsay, an exception to the hearsay rule. And then we go to the conclusion, which I believe is very important because it states, based on the above cited authority, the state respectfully prays for the court's approval in limine of the admission of the recordings and transcripts of the 911 call to Whitcomb on November 13th, 2022, immediately following the discovery of Xana Kernodle unresponsive at 1122 King Road. So it seems to sum up what the public has now learned for the first time, which was what led to the 911 call being made minutes before noon on November 13th, 2022. The rest of this document are the exhibits. Some are sealed, one is not, and it gives the statements that were made during the 911 call and the arrival of the officer. And if you recall from the affidavit of probable cause, that it was Officer Nunez's body cam of Kaylee's room with Murphy on it that was shown to Detective Brett Payne. And that's how Detective Brett Payne learned that upon arrival, Officer Nunez found Murphy in Kaylee's bedroom. This will now conclude this episode of the IndieZoNe. If you have any questions or comments, please leave them here. And until next time, thank you for joining us here today.